Numbers 23 and 24, Gravano versus Take-Two Interactive Software and Lohan versus Take-Two Interactive Software. Thank you. Good afternoon, Counsel.
Good afternoon, Your Honor. May it please the Court. My name is Thomas Farinella, and I represent the appellant, Karen Gravano. I would ask the Court for permission to reserve 2 minutes for rebuttal.
You may have 2 minutes, sir.
Thank you, Your Honor. Ms. Gravano respectfully asks this Court to reverse the appellate decision, the appellate division's decision to dismiss the motion to dismiss the action. The issues before this Court are whether or not plaintiff appellant has the right to sue under Section 51 of the New York Civil Rights Law, Section 51 based on defendant respondent's use of her portrait, which incorporates her likeness, voice, and
let me ask you this. Where would you identify, as to Ms. Gravano, the commercial exploitation of her image in this case? She's part of the storyline, right? Primarily, as I went through the record, she's part of the storyline in an episode called Burial. Am I correct in that?
You are correct in that, Your Honor.
All right. So let's assume for a moment that this is a work of satire or fiction, and if that's the case, then and it's incorporated within the story, then the question that comes to me is, how is this name, portrait, or picture of her somehow commercially exploited if it's part of a work of fiction? In other words, it isn't being used to sell it. Nobody has a DVD or a disc of this video game to be played, or a poster or a mug or anything with her image on it. So how is she being commercially exploited here?
Well, we believe that because she was a celebrity who had a reality show and 3 million followers, that in fact that would be something that would entice her fans and viewers to purchase the game. However, that we've contended is a factual. How
does that take place if there's no commercial exploitation of the image?
Well,
does that mean every historical novel is somehow a commercial exploitation of anyone who's living?
Well, in an instance when there is a substantial fictionalization and the person's name is used, yes. And we are contending that while
I thought the name used here was Botino.
That is correct. However, we are alleging that her portrait, in conjunction with the actual words spoken by her throughout the scenario in the burial mission, is in fact, a portrait is her likeness in terms of.
So the portrait is the game's graphics.
Correct.
Mm-hmm.
So where in the context, where was it commercially exploited? Was it used in any way to sell this game?
Well, we don't know. That's a factual question that we have argued, and that has also been the conclusion.
Just for allegation purposes, just for 3211 purposes, that's all I'm asking now.
For 3211 purposes, we've properly pled that they've used her portrait. Moving on to trade and advertising, we would ask that the Court would look to Second Circuit cases, Ali v. Playgirl, and also.
Now, Ali v. Playgirl, that was a cartoon, wasn't it, of Muhammad Ali?
Right. It was a caricature. So okay. We are arguing that this could and the key here is that.
So is every caricature then a question of fact which must go to a jury? That would mean every avatar in every video game could essentially become a jury question as to whether or not it's commercial exploitation.
Well, we're dealing with the record, whether or not the avatar is recognized to be the person, in this instance, Ms. Gravano. And Ms. Gravano actually found out about this particular portion because one of her fans tweeted her and said that we just saved you from being whacked, if you will.
Yeah, but isn't that the point? You already have purchased the game and you're playing the game. It's not that, let's assume for one moment, it is a portrait of her, just for one moment, that portrait has been distributed somewhere in a way that entices someone to purchase the game.
Could very
Someone
well,
who bought the game.
again, that's a question of fact. For example, in this day and age, they're using algorithms to determine what people like on Netflix.
Did you ask for discovery on that?
We're still at 3211, and the defendants have resisted, providing documentation because of the pending, at the time, pending motion to dismiss. And then it was
You alleged that it was used on a billboard or something? What, I know that's what the other side, Ms. Lohan's representatives have alleged.
Yes, we've realized that it's been used for trade within the context of the game itself.
Oh, okay, well, let me ask you that. What are you advocating is the interpretation of that phrase in the statute for purposes of trade?
Correct.
What's your interpretation of that?
And the interpretation is if, in fact, the work is commercial and it entices solicitation of the work because of that person being in the game, then the case should move forward. But
so if there's a newspaper article or a book or anything else, a comic book or whatever, and there's some likeness of a real person, and that is being sold, then that's enough to fit it into trade or advertising?
Well, trade or advertising has been an issue that should require further factual findings by the trier of fact.
But aren't there certain circumstances under which the courts have held as a matter of law that something is or isn't?
Not in this case. The appellate division.
No, not in this case, but in other cases. There are circumstances under which that can be determined as a matter of law without any factual issues.
Well, the problem is that there is, the case law in this area is confusing, but this case is simply unique because it's a video game, and that's what makes it different than the other mediums.
Thank you, counsel. Counsel?
Good afternoon. May it please the court. My name is Frank Daldone, of counsel to the Law Office of Robert Pritchard, attorneys for plaintiff appellant Lindsay Lohan. In this case, I'd like to reserve, with the permission of the court, 2 minutes for rebuttal.
You may, sir.
Thank you, Your Honor.
You're welcome.
First of all, the First Department erred. Whether something is a portrait, picture, or voice under the statute is a question of fact. Cohen versus Herbal Concepts, 1980.
It's always a question of fact?
Unless it's just so out of the, where no reasonable juror could ever possibly find that it's,
Does our case law say that?
well, Cohen versus Herbal Concepts specifically says it's a question of fact.
Yeah. Now, Cohen was was that the portrait of the woman with her daughter? That was a direct photograph, wasn't it, of
Correct,
the
Your
person?
Honor.
So the circumstances are a little bit different here, aren't they?
They're
Substantially different.
Substantially different. But
Right,
in Cohen
right.
versus Herbal Concepts, they cited Loftus versus Greenwich.
But they didn't say an
Lithograph.
avatar in a video game is.
No, but they did say artistic representation, citing Loftus versus Greenwich.
But weren't they also talking
lithograph.
about the fact that you couldn't necessarily see any features in that picture?
In Cohen?
In Cohen, yeah.
Other than, the faces weren't, you could see the backs of the
Exactly.
females, but not the face. But
One of the things I struggle with here, and probably most of the courts do it as technology changes, is what would the language be? What would you recommend to us as an objective matter of law test that we could apply in deciding when an avatar or a caricature is so similar to a petitioner or the portrait of a petitioner that it's as a matter of law either goes forward or doesn't go forward? How are we to make that determination? Or is it always a question of fact? Because you seem to be arguing it's always a question of fact.
well, it's the case law based on Loftus versus Greenwich lithographing and
What language would you use as an objective, not a subjective test that I think it looks this way, but some form of objective, reasonable person test?
Well, if a reasonable person could identify that as a portrait picture or voice of the plaintiff, I think it's a question of fact for a jury.
So any young blonde woman who wears a red bikini and carries a cell phone can get beyond?
Well, Loftus versus Greenwich lithographing also had the costume, which the actress in that photograph was in Greenwich, in Loftus versus Greenwich lithographing. The artist took a picture and painted a movie advertisement poster, which he changed her face but used the same pose and the same red costume, which everybody knew this actress from, and he intended the portrait to look like her. So therefore, the court said, because he deliberately tried to paint a portrait from the picture.
Is that not different than creating an avatar?
Well, I would argue that's the exact same thing. If you can create an avatar, you're using a computer to do it, but it's like painting. You're still making something. However you make it, the technology changed in that circumstance.
So if
I don't see any relevance.
So if I'm understanding you, your argument is that although portraits may appear to be what we have surrounding us,
Correct.
it's the exercise of the artist in rendering an image. And they may do that digitally or however they do that for this particular game, but this is what they're trying to do.
Correct.
And that's a portrait for purposes of the statute.
Very
the next
important.
question is, I take it you're saying, whether or not that image now really looks like, in your case, your client, Ms. Lohan, goes to the jury unless it's so obviously no one could think that that is her. Am I understanding your argument?
Yes, I think that's correct, Your Honor. I think it's a question of fact based on the case law that we have at this
Well,
point.
the second question would be, let's say even it looks like her, was there commercial exploitation here? You've got three sources. There's a scene called Escape from Paparazzi. I don't even see her face in that.
Her face is not in the avatar. Her face is only on the transition screen.
All right, so there's two transition screens, right? The stop and frisk and the beach weather scene is I think you refer to.
Correct, Your Honor. That's the bikini pose and the arrest pose.
Okay, and you're saying that that's where the question of fact is.
Well, I'm saying that those are the two portraits, the beach weather and the stop and frisk, the two portraits that are being used.
And it's somewhat different from Ms. Gravano because those are used as covers for the items being sold?
Ms. Lohan, the beach weather and stop and frisk images are on the disc covers, they're on the packaging, right. DVD covers, they're used on billboards. They're definitely used for commercial purposes. I don't think there's any issue as to that. But getting back to that portrait picture.
Well, if they're not, aren't they commercial exploitation anyway? I mean, isn't the point of this game that someone's going to buy it and use it?
That's a trade purpose.
Advertising has a different meaning.
That's correct, Justice Rivera.
I could advertise something and offer it for free. Could I not?
Yes, you could, but if once it's in the game and they sell the game and it's on the game itself, it becomes a trade.
But I'm saying, could not one
statute.
Advertise and offer something for free?
Sure, you
can. You need to be making money off the image.
No.
You seem to have somewhat of a statute of limitations problem, clearly with advertising, and I'm not exactly sure on trade, but perhaps with trade also. You want to address that?
Yes. Well, for trade purposes, the game was released on September 17, 2013. The complaint was filed and served in July of 2014. So when the game was released, it started, another element of this statute is trade usage. It started a limitations period for trade usage when the game was released. So that, to argue, the argument on that the statute of limitations has not expired on the trade usage element of Section 51 is obvious. It was filed within a year. Regarding the advertising images that I don't think they've initially met their burden as to when all the advertisements and through the internet and the dates that they were released on. They say it was more than a year before we filed our. I don't think they've met their burden initially establishing that. However, once the games are modified and put on the on the game itself, taken from posters down and switched around and recropped, and things are cut out of the scenes. These important items that they're saying are free speech protected are now cut out of the scene and put on, you know, the disc portions of the features are cut out. So the images are modified when they're put on the game and on the packaging. So that modification is a republication, which refreshes the statute of limitations, as cited in the Bonder case, which is the very case that they cite. If the image is if the image is modified or is intended to reach a new audience, it's considered a republication. The advertisements are intentionally directed at potential purchasers, and the people who purchase the game, and see the images in the game itself, they're actual game players. They're two different audiences. So the republication exception applies to the advertising images, but there is no question that the release of the game starts a trade usage period. But I think the most important point here is the advertising and trade purposes. What they're doing here, if we accept that the complaint says it's her portrait and voice, accept those allegations is true under 3211, so it's her portrait that's being flashed for a fleeting moment on two still transition screens in the game. Then my adversary says that portrait is illustrating the article of using these gameplay instructions that are next to it. When they advertise and put these images on the packaging, they remove the instructions. So they're just showing. Yeah,
but haven't we said that if it's being used in connection with something that it's a part of, that doesn't.
But when they're using the image in advertising, it's not shown. It's not shown.
I understand
it's not
that,
shown
but
illustrating.
But there's a connection. There's a connection
Somewhere else. But in Arrington versus New York Times.
No, it's not. In other words, it's not just taking her image and putting it on a bag of flour. It's taking her image and putting it on the cover to a game in which that image is a part of that
Well,
game.
I mean, the two transition screens don't move. They're not avatars in the game.
But they are images of an avatar in the game.
No, they're not images of an avatar in the game. They're images. The avatar has another face on it. The avatar only contains her voice. That's the avatar only contains her voice. The images.
Don't the still images serve a purpose in the game? They're not the gamer playing, I get that.
According to my adversary, Mr. Feigelson, they illustrate the gameplay instructions. That's the purpose he has in the game. It's part and parcel. So when I said there's no real connection to the game, he put in his brief and sought leave to put the instructions in his opposition brief that the portrait is illustrating these instructions. Then in the advertisements on the cover of the game and on the billboards, the instructions aren't there, so that the instructions were deliberately removed, so the advertisement appears in a different light than it's actually used within the work itself, which is the game.
So you're saying her image, in order to fall within this connection requirement, has to be the exact same image that's actually in the video?
Well, yes, that's what I am saying.
Your
yes,
position.
because yes, because if not, then you could take any movie and.
But you see the logical problem, which is that you've got an avatar. You're saying it's not the avatar that's in the storyline, right? That it's a different one. It's basically a different picture. So we've got now three templates for Ms. Lohan. Ms. Lohan herself, let me finish, the screenshots, and then the avatar in the game. You say the two within the game are not exactly the same, only her voice is being used as your allegation in the game, and that the other one is closer to a representation of her.
No, what we're saying, the allegations of the amended complaint is that the two still images are her portraits, that they deliberately drew from her pictures. They had the pictures in this hand and drew the portrait from those pictures. And but the main thing is, then you could take a still image of anybody and flash it in a movie, okay? And because it's part of the movie, then you can make an advertisement of that scene for the movie, of any portrait of anybody, if that's what I'm saying. Or if you're shooting a fictional movie in New York City and there's a portrait of Madonna hanging on the wall, okay, and there's actors there, and you take a still of that scene and there happens to be a portrait in the background, you could probably use that picture in advertising. But in the advertisement, if you cut out the actors and just show the picture of Madonna, you're deliberately changing the scene, you're deliberately changing the work, and you're just showing the advertisement. That's what they do.
Aren't you telling the person who you're trying to entice to see the film, play the game, buy the book, whatever it is, that the image they're seeing in that advertising is representative of who they're going to see in the work?
Well, you can't, but
Say Ms. Lohan's portrait is in the game, right? And then they just draw a different
well, then you can
version of her on the box as an ad. But the point is the same from your perspective, because you're saying it's my client's image and they didn't pay her for it.
Well, no. What I'm saying is you can't use somebody's portrait in advertising or trade without their consent. If you can use anybody's portrait within a work of art, if you're going to call it a fleeting reference or a use of a real person in a fictional circumstance to give the fictional scene context, however you want to use that real person's picture or reference the real person's name in a novel to give it context, a lot of fictional writers do that. You can do that as long as when you if it's a fleeting reference.
Put it on the cover of the novel, that's what you're saying.
If you use that, whatever the artist is trying to say there in that novel with that name there, fine, okay, that's permissible. But when you advertise with that, don't change the context. Instead of, if you mention Madonna on page 53 of the Notre Dame novel, okay, don't put a portrait of her on the cover of the novel and say it's a different use. Then it might be a permitted use to use her name on page 57 as a fleeting reference, but when you put her portrait on the cover of the novel, it becomes a different use. It's not an incidental use to a permissible use. It's a different use to a permissible use. It's a different use irrelevant to a permissible use. It's a different use. They use the images different in the advertisements than they appear in the game. Deliberately done. Therefore, our position is that they violated Section 51, advertising and trade purposes as a matter of law, because they deliberately changed the work in the advertisements.
Thank you, counsel. Counsel?
May it please the Court, Jeremy Fagelson, representing Take Two. Your Honors, there are two cases in front of you and one thread that will pull you through to affirmance in both, and that is that Grand Theft Auto 5 is a creative work of fiction. Creative works of fiction do not qualify.
To that end, would it help our analysis for future cases to basically turn this whole thing upside down and start with that as the threshold and not get into all these factual disputes about what is a likeness, what is a portrait, what is a voice?
I think that's exactly the right approach, Judge. I think when you start with the well-settled rule in this state that creative works do not qualify as trade or advertising, Section 51, as this Court has said over and over, is to be narrowly construed and limited to the circumstances that prompted it, which are the flour sack case that Your Honor mentioned, Roberson. And this is so clearly 180 degrees different from that. I think that's an excellent clean kill analytic path. It's one of the two reasons why the appellate division dismissed here, but it's really the only reason you need when a creative work is challenged in one of these cases.
Well, would that rule, if we went in your direction, would that totally destroy the right of publicity or the right of privacy under sections 50 and 51?
No, it would not totally destroy it, Judge.
So there would still be, you would say that the issue of commercial exploitation would still survive?
Well, I would say,
because the way you're reading it to me, it sounds to me like that once you put them in a work of fiction, we can do whatever we want with anything in there.
Your Honor, the test that we would suggest is already in this Court's cases. and you find it in Howell and Messenger and others. Newsworthiness and protection of creative works have always been treated as two sides of the same coin. In the newsworthiness cases, this court has said, as long as there is any real relationship between the subject matter of the work and the challenge
So let's
use.
talk about the details just a little then.
Yeah.
It seems in the Lohan case, we're really focusing down on the beach weather and the stop and frisk images. And is it your contention that those images are part of the storyline of the video game?
Grand Theft Auto 5, Your Honor, is like an interactive movie. And the transition screen artworks are like what you see in the credits of a movie. They are among the very first things you'll see. There's 10 of them, not just these two, and they sort of roll across the screen while the game is loading. Okay? So what they are there to do is to introduce the player to the world of Los Santos, this incredibly rich visual and fictional world that they're about to experience.
Some might call it mind-numbing, but okay.
But do you ever come across them again? If the work of fiction is the gaming experience, where do you come across these things again?
The work of, you do not see the beach weather and stop and frisk images again in the game. What you do see in the game repeatedly are the settings that those images introduce.
Well, the bottom line is here, the images are not used in the game, right? They're not, those images, that person, whatever that avatar is, it's not used in the game.
Those two persons are not characters in the game, but the settings that they introduce in the transition screen artworks are very much part and parcel
But what's the
of the
part
game.
of the work of fiction? If the work of fiction is the game itself, is that what you call that interactive gaming part of it, and these two images are never part of that experience, how are they also part of this work of fiction?
They are the table setters, Judge. They are the introduction to the world of Los Santos, which is this incredibly
You could certainly do that only with those who are in the game. So what's the purpose of these others that goes towards the work of fiction itself?
The work of fiction, Your Honor, is a satire of modern life in Southern California.
Yes, I've seen it. Thank you
And
for the demo.
you're welcome, Your Honor. And what these images do is, they are examples of, the type of, Southern California imagery that's just going to saturate the game. Here's the party girl.
Right, but they
who got
never
into a
show
little
up again.
trouble. No,
Those images never show up again.
They do
You
not.
agree with me, yes?
I would agree, Your Honor, but the experience of the transition screen artworks is part and parcel of the game. You can't play the game without
Okay, so
loading
let's
it and
say,
experiencing
so
them.
what's the test we apply to distinguish between these images? Between an image of Ms. Lohan, Ms. Gravano, and then the transition images and the avatars in the game. We have three sets of images that we're dealing with. How do we distinguish them? What legal test can we apply to do that?
Okay. It's the no real relationship test, Judge, from Howell, Messenger, and other Section 51 cases from this court. And what this court has said very explicitly, and going back to Notre Dame, is we're not.
Let me just stop you for
I'm
a
sorry.
second, and then you go ahead. I agree with you. Messenger may apply, but what I'm wondering is how does this not become a question of fact?
Your Honor, we're dealing with the protection of creativity, which this court has said is a fundamental concern of the statute. The First Amendment concerns are implicated here.
So that would narrow us, let me just finish then. So that'd take out the escape from paparazzi. That's the protection of creativity, the work of fiction, that's within the storyline. Let's forget about anything inside the storyline. Even Ms. Gravano, let's forget about. What about the two images which are used, I guess, on the front of the packages that sell the DVDs? Well, they're like DVDs, I guess, that go in the. Is that correct?
You will see them on certain versions of the packaging. Okay. Your Honor, the transition screen artworks, I'm calling them artworks for a reason. They are rich visual works of art in and of themselves.
Well, how does this dovetail with the law about advertising in disguise? So, you say, okay, well, it's all a part of the setting, the scene and everything, but well, let's just say for the sake of argument that you have intentionally created this to look like Lindsay Lohan, and Lindsay Lohan isn't a part of the of the game or what goes on in this world, but it's just at the very beginning, and it could be you could put anybody, you could have anybody, but so the question is how do we distinguish between that it's really a part of setting the scene versus, yeah, you did this because Lindsay Lohan will sell the game.
Well, Your Honor, let's keep in mind that in this case, the plaintiff's entire theory is that all three characters are Lindsay Lohan.
No,
So
I understand that.
maybe-
I'm just assuming it for the purpose of my discussion, for my question.
Okay. And again, I think I think the no real relationship test, Judge, will see you through. What this court has said is it's going to be very deferential to creators, content creators.
So, but then
and-
doesn't the no real relationship test always be an issue of fact?
no-
How do we determine that?
No, Judge, it will not always be an issue of fact. In fact, it'll rarely be an issue
You
of
got
fact.
three images, and why isn't it here a question of fact?
As to whether there's a real relationship?
Well, just to make the decision, if whether or not it's Lohan or it isn't Lohan, how do we decide that?
What this court has said before is it's not going to second-guess editorial and creative judgments. This court will not sit.
No, that's not what I'm asking you. What I'm asking you is you've got three images. They say it's Lohan, you say it's not. How do we decide that?
Is it whether it's a portrait or picture?
Right.
Okay, which is a
It's a
different...
matter of law now,
Okay.
that this generic young woman is Lindsay Lohan or isn't.
Well, I'd suggest you could look to the Onassis case, Judge, where the court used words like counterfeit and illusion. It really should be that strong. The image has to be the plaintiff. And that's an objective test. Your Honor brought up Cohen.
Right.
And Cohen specifically refers to the role of the court as the gatekeeper. The court is going to do its own objective check
Counsel,
as to the
may I-
quality and quantity of visual
May I
references.
ask a question?
Yes, Mr. Garcia.
Let me flip what Judge Feynman was, the way Judge Feynman was approaching this, and ask, if we find this isn't name, portrait, picture, or voice, do we need to get to advertising or trade at all? If we find it is not.
If you find it is not portrait or picture?
Right.
You could choose either issue, Judge, and affirm on either basis, absolutely.
So then we would not get into whether, under this creative work theory, you could take someone's actual photo, voice, and put it into whatever work, and we'd have to decide, is that creative, is that not creative? When can you do that? Is it a First Amendment violation? So if you go with the first test, name, portrait, picture, or voice, and assume, I know there's some dispute over voice, but assume this is over portrait, right? So to get back, I think, to what Judge Fahey was asking, what case, what test would we apply at this stage, 3211, to say that this was not a portrait?
I think you'd look at Onassis and say that you just see the objective differences, which are in the record, stark objective differences between the plaintiff and the characters in the game, and say that's not a counterfeit, that's not an illusion, that's a work of art.
And there would have to be some gatekeeping function at this stage of the litigation, otherwise anyone can bring this, get by motion to dismiss, and we'd have 15 different people claiming they were one avatar.
Exactly, and Judge DeFiore, to your point, I'd encourage anyone who's interested to go Google, blonde woman, red bikini. You will get 7 million hits. Okay, these images are generic cultural types. They are not the plaintiff. Okay, and this
Well,
court.
I thought they were arguing there were other aspects of the image that went beyond just the blonde female in a red bikini. So the way she's holding her pose, the hand, whatever else she has on besides the bikini, perhaps a particular smirk on her face.
Well, there is a suggestion
And
of that.
doesn't that then become a question for the jury?
No, in fact, that takes us even further away from anything that a jury should ever hear, Judge, because now what the plaintiff is really arguing is it's not my portrait or picture, it's my persona, it's my style, it's the clothing I like to wear. And no one has property rights in those. Lindsay Lohan is essentially arguing that she owns the peace sign in this case, and I think that Winston Churchill would be surprised to hear that. And Richard Nixon would be surprised to hear that. So, no, we're...
Doesn't your argument really boil down to that if you look at this image, it doesn't look enough like her to be her? In other words, if the face really looked like her, no doubt in anyone's mind, you would be arguing something else.
On the portrait or picture element, Judge, yes.
Well,
I
no, a
would agree
picture,
with
I'm
that.
thinking of a photo. A portrait
Right, okay.
is a creation of an image through some other medium.
Sure.
Again, what's
Agreed.
around us versus
Yes.
the digital.
We are surrounded by portraits, I would agree, Your
But
Honor.
here we're talking about digital.
And now we're talking about pictures, which
Or
is
whatever
a broader
software you
term.
use.
But no, there is an objective gatekeeping function for the court to play to ensure that that sort of counterfeit or illusion standard is met, or
But
else...
isn't your argument also, it's larger than, that? What you're saying is our gatekeeping function becomes all the more important because of the First Amendment concerns in any work of art.
Absolutely, Judge, and And I would really underscore this U.S. Supreme Court's decision in Brown in that regard, where video games were squarely before the court, and the question was what level of First Amendment protection do they get? And the resounding answer from that court was the highest level of First Amendment protection.
Yeah, but I think in part we're back to an earlier round of questions, which is when the image has nothing to do with the work of fiction and the gaming experience, is it really a work of art in the way you are describing it? Does it really fit within this other video game example you're using?
Your Honor, the two transition screen artworks that are challenged here are works of art on two separate grounds. They are standalone, rich visual works of popular art, and they are, in fact, part and parcel of the game experience. There is no way to view them within the game. There's no way to avoid viewing them, actually, when you are beginning to play the game. And they are not just depicting the two women, they are depicting the physical setting, the geographic setting of the game.
So,
and that's a creative purpose.
no, but I think you're missing, or perhaps I'm not being clear with my point.
I'm sure it's me. Right.
I'm not disagreeing with you that there's an artistic quality to the imagery. I'm not disagreeing with that at all. The question is, even that artistic image, if it's not part of that gaming storyline, that it's not really part of the work of fiction, which is what's being recognized as the work of art that gets protection or isn't covered by the statute, and then that image is used on the outside boxes Judge Fahey described to sell the product, don't you now fit within 50 and 51 because the image you've chosen is not part of that work of art? It is an artwork. I'm not going to disagree with you about the richness of the image.
Well, Your Honor, it doesn't have to be part of the narrative gameplay to be part of the work any more than something that you only see in the, if we saw an image in the credits of a movie and that image didn't recur, if the image is sort of playing out behind the opening credits of a movie, we'd still say that's part of the experience that the consumer of the artwork is enjoying. So I don't think you can separate the transition screen artworks
since it only
from the game.
comes up when it's loading, a gamer can walk away, right? I mean, they can enjoy this work without ever looking at that.
Well, a gamer could walk away from the game at any point. It's an open world game. The gamer can enjoy it in any number of different ways. But these are, independent visual artworks in their own right, and the connection of the transition screen artworks to the game is very strong in the minds of players of these games. They are a regular feature of video games. They're widely enjoyed, widely consumed. There's a reason they were used in the advertising. Exactly because of that.
But you would agree that there may be some circumstances, some exemptions for fiction, and for example, we have the newsworthiness exemption, right, in this whole framework of the civil rights law. Do you see any way that could fit within this? Within this area?
The newsworthiness exemption, Judge, and the exemption for creative works really are just, as I said before, two sides of the same coin. It really is the same protections as the appellate division said in Foster. Works of art are simply not trade or advertising. And that applies broadly. Movies have been protected, books, television shows, all forms of creative works. Video games just fall in line with all the creative works that have historically, all the courts in the state, starting with this court in Notre Dame.
But it's not absolute. There are situations in which publicity claims can survive First Amendment challenges, right?
A low bar is not no bar, Judge, but it is a low bar. It's a deferential test, deferential to First Amendment interests, deferential
Could we use
to the
that same
creators.
analysis within the newsworthy
No real relationship is the test that's been applied in the newsworthiness cases, and I'm suggesting it just ports right over, that it's deferential. It's that the court applies its gatekeeping function right up front, determines that this is a creative work, and therefore it's not trade, it's not advertising, and therefore you can use excerpts from it to advertise it. And there are multiple cases in our briefs that stand for that proposition.
If we decide, if we were, as a matter of law, that there is no real relationship between these still screens and the experience, you lose.
If you decide as a matter of law that there's no real relationship, that would be the implication, Judge, but that's objectively simply not a supportable conclusion. I want to emphasize...
Well, isn't that if we just come out one moment from the imagery that we're talking about here. If you took a picture of Lindsay Lohan, put her on the cover of Grand Theft Auto, had one slide pass by the gamer's image for 2 seconds, does that violate the statute?
If,
It never shows up again.
never shows
2
up again.
seconds while the thing is loading. Never, it's not part of the storyline. The gamer will never come across not only that image, anyone like her.
I think you'd have to look at the exact context, Judge, and see what's the totality of the image and what context is it being presented and for what purpose, and potentially.
Well, here's the purpose. You have it on the cover. I like Lindsay Lohan. I'll buy anything that has her picture on it. I'm buying it, and you put the one picture inside so that she can't sue you.
Well, Ron, let's start with the premise that you can use actual photographs in creative works, and there are multiple cases that say that. That was also part of Foster. Hector.
Absolutely, but I thought your argument was the creative work is the gaming experience of
No,
Grand
the creative
Theft Auto.
work is, and the gaming experience includes the entry into the game, just like.
So if that shot, we'll just use a picture because it makes it easier, of her, so there's no debate that it's her, for 2 seconds as the game is loading. The gamer may blink and not see this. You say it's still part of that work of art, that gaming experience.
I'm saying, number one, according to this plaintiff's theory, since she's actually in the game, in the escape paparazzi sequence, clearly yes.
For that image, I'm talking about the ones that are never shown again.
In your hypothetical, Judge, but we're going with the plaintiff's theory here, which is that she's actually in the game. She is not just in the transition screen artworks. So,
but my hypothetical is pushing
different.
that question, right?
Your hypothetical is pushing it. Now, if we stipulate, Judge, that it is a photograph of her and it's completely detached from the visual context of the game, we're not using it to introduce the broader scenery of the game, the visual look and feel of the game. We're not using it to convey information about how to play the game. Right. It's just a picture of a celebrity dropped in. Then I think the no real relationship test will see you through, and you could conclude that that's an issue of fact. It's just not this case. I know my red light is on. If I could ask the Court's indulgence for 30 more seconds.
May.
This is the legal rule here that we are asking this Court to continue enforcing. The rule that creative works simply are not trade or advertising is a rule that has been bedrock in this state and recognized really by creators all around this country, many of whom before the Court as amici. It's the rule that brings us Forrest Gump. It's the rule that brings us the George Steinbrenner and Soup Nazi characters on Seinfeld. It's the rule that brings us the novel Primary Colors. It's the rule that allows Andy Warhol to paint celebrities and museums to advertise those paintings, to advertise exhibitions of those paintings with those paintings. This is bedrock. It's very important to the creative community in this country that the rule be continued and preserved. The amici and we are simply asking this Court to stay the course.
Thank you, counsel.
Thank you.
Mr. Farinella?
Thank you. With regard to the First Amendment issue in this particular case, the Appellate Division relied on the Brown case, which is a content ban restriction case. So, you know, in the context of these facts here, it's an inapposite, because when you're dealing with a content ban restriction under strict scrutiny, it's a different analysis. Commercial speech in and of itself is not protected. I mean, there's been a Third Circuit case dealing with video games, and in the Ninth Circuit, they have determined that where a likeness is used, there's an actionable claim. I would respectfully ask the Court to point to the Second Circuit in Ali versus Playgirl, and then also, which basically stands for the proposition that the civil rights law, not restricted to actual photos, but compromises any representation which are recognizable as likeness of the complaining individual, and Titan Sports as well, which does go on to explain that trade and advertising is a question of fact. And that the First Amendment protection is a genuine issue of material fact as to whether or not it is protected by the First Amendment. But to point out with the Onassis case, in my particular case, the Onassis case stood for the proposition that imitations of a person's face intended to portray the impression that the picture is that of such person may constitute a use of picture-portrait. In my particular case, I went through an analysis of the similarities in the facial structure, in the individual uniqueness of, or the similarities in the hair color, and other similarities within the character itself. But more importantly, I also was able to demonstrate through independent people in the world who've reached out to my client, believing that character to be her. So,
Mr. Daldon?
Thank you, Your Honor. First of all, we didn't concede that these aren't Ms. Lohan's pictures, as my adversary keeps saying. We are alleging that they are her portraits, her digital portraits, intentionally and deliberately made to be her. That's the first thing. And I think I may have misspoke before. In the Cohen case, I think Cohen required an affidavit from a person, or there was an affidavit from a person recognizing the photograph, and the court used that.
The husband's, wasn't it?
Pardon, Your Honor?
It was the husband's affidavit, I
Yes.
thought.
So not only would it have to be, could a reasonable person find that the photograph was her portrait, but it's, in that case.
You understand, though, that factually, this is kind of a long way from Cohen, I think.
Pardon you?
Factually, this seems like a long way from Cohen. The factual circumstances here seem much different.
But there has to be, based on the current state of where it seems now, there has to be some evidence in that direction that it is, it can be recognized as her portrait. I think her brother, in this case, there's an affidavit from her brother that he recognized the beach weather portrait as her. And it's not,
okay.
I'm sorry.
I get your point.
So there's additional, there has to be some evidence in that direction. But I think the main thing is if the work, how these still portraits appear in the work, okay, if it's important with these instructions and in the credits of the scene, if you're going to change that in the advertising, it's just a different use on the cover or on the box. The advertising team is changing the work. They're cutting away the instructions and not only the instructions, but the rest of the scene that this portrait is supposed to be illustrating and illuminating, and just put the portrait on the screen. So to
me, that's a lot of fine line drawing. I think, you know, I think the tougher question really is what, if any, purpose does it serve inside once you open it up to play the game? And are the, you know, and how are the two connected?
And it's supposed to be illustrating these instructions, and once you detach that, it's a different use, in my judgment. You're changing the artist's, the advertising team is changing the artist's perspective, whatever it was. I don't want to step on the artist's toes, but if you're going to advertise it, advertise what the artist was trying to say. Don't change it and say into something else and then call it, try to pull rank with free speech.
Well, how would they have done that? I mean, if, I'm trying to remember back the imagery, how would they have done that for that still image with whatever that, I think you're talking about that circle next to it that shows, right, the character you can play? Is that what you're talking about? What's the difference, you say, between the image, let me do it this way, the image in the game versus on the box?
Well, the image in the game itself are the transition screens on page 11 and 12 of the brief, and you can see the portrait.
Yes.
With the scene in the background and illuminating, as Mr. Feigelson says, the vital gameplay instructions.
Okay.
I'll take the artist's word for it, Mr. Feigelson's word for it.
So you mean that imagery that's in the brief, if they had just put that on the cover of whatever they're selling in the ad, you're saying that's if they had done the exact same thing?
That they would have a better argument to coming within the exception that way, because you're not changing what the artist was trying to say. You're using the artist's whole scene. Whatever the artist was trying to say, whatever it was, is used in the advertising. It might be an incidental use to a permitted use. But in this case, they change it. You cut out half of the scene, you cut out the rides in the background, you cut off half of the car, you cut off half of the car, and you cut out the vital gameplay instructions, as they say. It's a different use now. The image is changed, deliberately changed by the advertising team and the packaging team when they made it. They took the artist's concept, whatever he was trying to say, and changed it.
All right, so maybe maybe I just don't understand the statute, but the point is the portrait itself. Everything that you're talking about is the portrait itself, right?
Well, if you just use the portrait in the game, okay, and there's no relationship to anything in the game, then there's no real relationship, and it's an advertisement in disguise. So you just can't.
My example about the picture that's on the cover and that's in the game for 2 seconds.
Yeah,
unconnected to anything.
Unconnected to anything, right? Then that's an advertisement in disguise because there's no connection to playing the video game. Here, the connection to playing the video game is. I mean, it's just not there. The experience of playing a video game is, wow, this is real, this is live. Mm-hmm. You know, you can stick a transition screen of anybody in there and say, oh, you know, it's a fleeting reference, it's a permissible use, it's a fleeting reference in a work of fiction, and then put it on the cover and say, we're protected. Okay. I say no. I think it's just there's no real relationship there. But even if you want to go that far and say that, if the artist is going to say something on a screen, whatever it is, and we're going to let him do that as a use of a real person in a fictional setting to give a context, when you advertise it, the advertising team shouldn't change that image and say it's protected. They should use the same image and not step on the artist's toes and change what the artist was trying to say.
Thank you, counsel.
Thank you, Your Honor.